So this is where the rubber meets the road. What is happening in the courts? Because that's, I think, where it really counts. And that's what we will discuss in this next session. But before we get going, I would be remiss if I didn't thank Joel Erickson, who was in charge of all the logistics for this meeting. And he's done a terrific job, and he's been assisted by Nate Weisenberg. So could we have a round of applause for... This session is going to be chaired by Joe Cecil, who is a former senior researcher at the Federal Judicial Center and is now a fellow at the Berkeley School of Law. Joe. No presentations.
Thank you, Debbie. The rubber meet the road comment reminds me that after the National Academy of Sciences report, I was with a friend having beer, and I explained to my friend, who was from the law enforcement community, this great new report we put out and how important it is to have validity and reliability. And I talked about fingerprint minutia. I talked about lands and grooves and firearm identification. And at the end of what I thought was a stellar presentation, he took a sip of beer and said, "Sounds like you really know where the rubber meets the clouds." But as Debbie said, we've moved beyond that now. Now we're talking about the importance of forensic science in the critical role of both exonerating and convicting individuals. And we have an excellent panel to assist us with that. The speakers, let me just introduce all the speakers, and then we will just, each one will have about 10 or 15 minutes. Then I expect a lot of questions as we go forward. Mark Larson is the Chief Deputy Prosecutor of the Criminal Division of the King County Prosecutor's Office in Washington State. Mark also has a number of distinguished publications in eyewitness identification, if you're interested in that topic. Julia Leighton is recently retired for General Counsel from the Public Defender Service in the District of Columbia. And Julia also served on the National Commission on Forensic Sciences. And Chief Justice Bridget McCormack, who is Chief Justice of the Michigan Supreme Court. And Chief Justice McCormack approaches this issue not only from her role at the apex of the Michigan court system, but also as a legal scholar. And so why don't we just start with Mark? We'll have 15 minutes or so, 10 minutes.
Good afternoon, I'm Mark Larson, and King County is it's Seattle, home of the $5 cup of coffee. You're welcome. That's one of our claims to fame. I am it's very impactful to be here amongst all of you. I spend a lot of time with a lot of lawyers, and to be with folks that are moving this issue forward and seeing the progress that's being made in so many important ways is really been remarkable and eye-opening. So thank you for including me today. You know, I start with this proposition too, that I think about how incredibly parochial so much of criminal justice is when we think of the United States. And it's really the issue that we're sort of trying to work against in so many different ways, and forensic science is, of course, one of them. And I looked at with such envy at our friends from Australia, and I thought of being able to work with, I think, 6 police departments kind of in Australia, roughly. 9. In King County, I have 40. That I work with that are actively, so you know, we just have such a different way of sort of organizing ourselves, and in some ways I think Americans, we hate government, so we keep creating more and more layers of government underneath government. So it's an amazing patchwork to have to navigate and to sort of make changes and to sort of come out of a 10-year period, a report from 10 years ago, and say, where are we? Because where do you measure, where do you look, who do you talk to, how do you find out? And these are the sort of events where I come and find out that we've made more progress than I could have imagined when I was writing some remarks flying out here. So I'm delighted to find that to be the case. I was also, I was impacted this morning. I was thinking about the sort of the grand idea that came out 10 years ago, which was a National Institute of Forensic Science, and truly a grand idea and a really powerful and good idea, and I don't know what happened to it. If somebody tells me later how that didn't ever make it up to the fore, I'd be interested. But I'm also, it's remarkable to think about what replaced it. And gosh, John Butler, I think, did that horizontal thing today. And we didn't get one big organization, but my God, the volume of groups and institutions and actors that sort of have grabbed the mantle and moved things forward is astounding. And again, the progress that's been made is remarkable. I guess I want to talk really briefly about the courtroom, and remembering too that I think I'm the only, we're both state court practitioners, but much of the discussion centers about federal court and the federal court rules and ER 702 and the Dalbert standard. I'm in state court, where the bulk of, and I'm representative only to the extent that that's where the vast majority of criminal justice and forensic science is going to be offered into evidence across the country. Washington is a FRI jurisdiction as well, and for those of you, I'm sure you'll hear more about that, but FRI is the older standard and one that looks at whether or not sort of general acceptance of a science within a particular field, and that sort of is the touchstone for judges to admit evidence there. So it's older and perhaps outdated, but it's what we still have. I would say that having been there a long time, though, I can tell you I do remember the NAS report when it came out. I remember it probably shivered my timbers and what's it going to do to my cases and what's going to happen to my lawyers, and there was probably some general nervousness. And like so many things, not that much really happened. To be honest, there wasn't some groundswell, there wasn't some huge change, no tsunami washed up and changed everything for us. I do recall, and I checked around in my office because I've remembered a few of my colleagues having fights over certain particular sciences, matching source identification sciences, and there were some challenges that came out of that original report. I don't think they were successful, and I don't think they had much of a lasting impact, to be quite honest. But what had happened to all of us is we'd lived through the advent of DNA being introduced into courts forensically, and that happened for us in the mid 90s and onward, and it continues. But that really, I think, did sort of change so much of how as we oriented to this incredibly powerful science with enormous powers of discrimination. I think that caused a lot of us to start connecting dots to other sorts of forensic sciences that were being used in very, very powerful ways, but were obviously so very different from DNA as well. We have continued to litigate DNA issues out in Washington State using our standards. Certainly ever new types of DNA in terms of the power of discrimination, the ability to use smaller and smaller samples. Most recently, we've been litigating the complex mixtures, how we sort of, probabilistic genotyping has been used. True allele was discussed earlier. We brought that to the courts in Washington. Most recently now, we have several cases involving genealogy and the use of DNA there, which I'm not sure is going to be a huge legal issue as much as an ethics issue that people are discussing even now. I will say, though, that what has been, it struck me as I thought about the decade, there are things that have been displaced and replaced. And we don't have much in the way of bite marks, document examiners. I think we have 2 document examiners for the state of Washington, and they're not kept busy. And I thought, well, why would they not be kept busy? Well, it's because of the other emerging thing, which is digital evidence. People don't write stuff down anymore. And maybe they do on forms to send things to the crime lab, but not much else. And so our lives now are contained and played out in this very, very different form, which is digital evidence. And that's the place where we do care deeply, and where so much more of our cases are I think being improved by the aggressive use of video, phones, computers, and the issues surrounding authenticating that evidence, analyzing it accurately. I know there's some recent debate about the use of cell tower pinging and whether that technology has been represented accurately in court. But that's really where I see all of the movement heading toward is the use of the understanding and the presentation of electronic evidence in our courtrooms. The rest of this will all remain important, but I see that as sort of the trend forward. Those are the things that I see going on in the courtroom. A little bit behind the scenes in terms of the role of the prosecutor, I would add two other things. We're responsible when we come across potential witnesses who are subject to being recurrent witnesses, police officers, crime lab analysts, and others. When we come to believe that people have offered unreliable, and I think in the vernacular that was used earlier, intentional and unreliable testimony or results, or they reported something that we know is wrong, we keep track of that. And if and when that witness ever appears again in some court, when the subpoena gets generated in my office, we know that, and we're able to notify defense lawyers to say, hey, you need to pay attention to this particular forensic examiner. Oftentimes that could be a lie or die situation. Sometimes they're not there, but we've had that situation where we have had them on our Brady list or our potential impeachment list as part of their crime lab responsibilities. The other place where it's coming up, and I think this is not entirely new, but an emerging sort of trend for prosecutors, is looking at conviction review. And as we look at old cases, sometimes we're looking at them on our own. Oftentimes they're being brought to us by various advocates who want us to examine some old case. And we are being asked to look at a variety of types of evidence from those cases, and we know from the exonerations. We're looking at eyewitness cases, we're looking at the use of cooperating witnesses, also known as snitches, but forensic science falls right under there as other sorts of things that we need to look at. And so we need to be really sensitive to understanding how forensics of yesterday may have played into cases where convictions were won, and we need to reevaluate and look at those earnestly as thoughtful prosecutors living in modern times. The final thing I want to talk about in terms of changes is language, and I know there will be more discussion about that. And Joe, I know you have a big interest in the ultra, however you guys pronounce it. But I checked with our crime lab because I wanted to make sure I understood this, how generally they're going forward. And I sent them the proposed DOJ standards. They were convinced that they are using virtually similar kind of language. But I don't want to mask that as sort of a detail, because I think as you move across some of these sciences and you look at them, how they present themselves forensically and otherwise, it's not that I think so much we want to exclude them from the court necessarily, but it is extremely important that how that evidence is sort of conveyed to a jury or a judge, what the meaning of it is, what weight should be given to it, is impacted enormously by the way in which those findings are expressed. So the fact that change is taking place and that is sort of moving forward, I think is enormously important. The last thing I'll say is this: that I did talk to my crime lab before I came out here to make sure I understood kind of where they were. They are affiliated with our state patrol. And I know that that's a criticism because, the obvious bias can happen when you feel like you're always moving forward criminal investigations or you're in partnership some way. I will say that the sentiment in my office is the opposite, only because I think we have pretty good scientists who are pretty clear with the limitations of what they can do. But more importantly, they compete with funding for people who wear hats and go out on the road and write tickets and do a lot of sexy things. And we're convinced that because they're buried in the state patrol, they really do not get the resources that they might if they were more independent. So that's something that we would support. They are accredited. They're proud of that, although I appreciate that that's a minimum standard. That's not something to celebrate. It's not the game over. But they are proud of the fact that they're accredited by ANAB, and they use ISO standards. I think they are. More importantly, when I asked them about some of the issues that were coming up here, I expected more of a "we've got this" mark, and that's not really what I got. What I got was go tell us what you find out. We want to be current. We're interested in knowing if there's additional testing or metrology or things. If there are things that we can bring to bear, we're not uninterested in that, and we would like to know how to be a part of a larger community that is moving the issues forward. We want to be at the forefront of that, and that really kind of warmed me as much as anything else. The other thing that reminded me, though, to be cognizant of how rapidly their environment is changing, whether it's instrumentation or additional testing or new things that they're doing, they are pressing forward into a lot of things consider. Their world is changing rapidly and all the time. So I won't say much more about, I guess this is the last thing I'll say, and I've already said that once before, forgive me. I think, since I'm the only prosecutor on the stage, I will say that there's no doubt that our country is living in a period of time when we were thinking about and scrutinizing criminal justice and criminal justice outcomes in new and important ways. And whether we like it or not, prosecutors find themselves either at or near the center of a lot of those discussions. And I think, we can either sort of run away from that or feel like it's unfair, or we can be defensive. But I think the opposite. I think it's deserved. I think the attention is something that is good for us. And I think it gives us a chance to really think about our culture and to brand who we want to be as we move through these issues. And so when I think of whether it's exonerations or Brady lists or really just the culture of offices, I am intensely interested in sort of moving forward an idea that we also are gatekeepers of the quality and the type of evidence that goes into court, and that we're not simply trying to bend people's arms to say the thing that we want to sort of help us win a conviction. And I hope that that's what we're trying to accomplish in King County. But I think it's a part of not just a local trend. I think that's really the pressure thoughtful prosecutors are feeling across the country, and we should be. And we should be moving into that. So that's all I've got.
Thank you, Mark. That's very helpful. Julian, what is the defense attorney's perspective on this?
Retired defense.
Am I there? Okay. Well, let me first start by saying thank you. Thank you very much for inviting me to come and join this panel, and more importantly for me, to have brought together this kind of a collection of folks that includes independent research scientists, forensic scientists, and the legal community. Because I'm afraid it's my opinion that in the 10 years since the National Academy of Sciences report was issued, that what progress has been made by groups like this, not courts. I think that it is this sort of collaborative setting that has started to move the ball forward to reach the point, and this is my defense perspective, to reach the point, which I don't think we've reached yet, where forensic evidence that's introduced into court, the forensic methods have been validated, and that the error rate and the limitations can be articulated and explained to a jury so that they can meaningfully evaluate what weight to give the evidence. But I don't think we're there yet, and I'm previewing who I think is going to get us there, and I fear that it is not the courts, and it's not even the well-meaning prosecutors that I sit next to, and not all are quite so open-minded. I think that when the 2009 report came out, the defense community thought, well, no, I shouldn't say that, because there are too many that didn't read it. But many of us in the defense community thought, hooray. Here we have the National Resources Council that vetted and selected renowned experts that were uniquely situated to answer the question that was being put to them by Congress and by the forensic science community. Right? And their conclusion was that but for DNA evidence, the forensic science professionals hadn't demonstrated the validity or the accuracy of their methods. And that was, I think most would agree, it was a stunning revelation to the legal community. Maybe not to scientists, but it was stunning to the criminal justice community. And despite that, we thought that this has got to be a document that's going to bring about profound and immediate change. And we couldn't have been more wrong. In a word, let me start by saying, with notable exceptions, I'm going to generalize about what I saw, not only in Washington, D.C., but I do a lot of training throughout the country and work with a number of public defender offices throughout the country. So what we were seeing throughout the country was, in the first instance, outrage from the forensic science community, a full-throttled defense of the status quo from most prosecutors, present company excluded. Too few few defense attorneys reading the report, let alone presenting a persuasive record to the court about what the report, of putting a persuasive, of explaining persuasively to courts the meaning behind the report. And the courts, I'm just going to pick on everybody up here, but I have picked on me too, so I'm going to pick on everybody. The courts basically said, look, we've always done it this way. I've got lots of court history that says we do it this way, and I am not going to be the first judge to do it differently. And I even had one judge say, you can file that report, but don't expect me to read it. So when I step back from that a little, I think this really shouldn't have been that surprising, right? The report, I think and you know, I'm curious to hear how others and get reactions from the audience, but I think the report to the forensic science community, not everyone, but to many, felt like an attack on their integrity. It shouldn't have been perceived that way, but I think it felt like that. It felt like an attack on their integrity. It felt like an attack on decades of work that they had done conscientiously following the procedures that were given to them. I think the full-throttle defense from the government, not everyone, but I wish I could play for you all, but we aren't doing PowerPoints. We're the pictureless group. You know, some of the statements made by the leadership of the National Association of District Attorneys, it was very dismissive of the report. And I think that came from the fact that we exist in an adversarial world. That for line prosecutors and line defense attorneys, it's about winning. Make no mistake about it. We're evaluated by how well we do. Our clients evaluate us by how well we do. Prosecutors' supervisors evaluate them by whether they win or lose. We're in an adversarial system, and it's a lot to ask prosecutors, many of whom have their own caseloads, who rely on the forensic examiners and what they say, after all, they're not scientists, to essentially back off an advantage that they have, to back off an advantage when the courts are letting it in. So I think that there was a reason why all the players came out the way they came out, and for the defense community, you know, some of it was incompetence. I have to own that. Some of it was people just didn't read the report and pay attention. But there's also, I think, as probably many of you know, a crisis in the indigent defense community. And that's who defends most criminal cases, are court-appointed lawyers and public defenders. And the caseloads are, in many, many jurisdictions, appalling. It is everything lawyers can do to meet their clients and read their case file before they walk into a court, let alone just investigate the basic facts, finding out who the witnesses are. And some of this is complicated, made more difficult by the discovery rules. That it is, in criminal cases, unlike in civil cases, the government doesn't need to tell me who their witnesses are. I don't get to depose their witnesses. There are some jurisdictions that are exceptions, but for the most part, I have to figure out what their case is. I have to start from scratch and investigate. So it takes a lot of resources. And if you're going to add to that I have to read a 160-page report, understand it, and even more difficult, go find experts who could help me make the report come alive for the court, that's next to impossible for almost all public defender offices. And, you know, as you've heard, there are like 400 some accredited crime labs across the country. I think there are probably more if you start looking at what's in all the police departments. Maybe there's one or two sort of defense-like labs, but there are no defense think tanks. There's no system of defense community research that's being done in this area. It's not like the civil sector where there's money to be made by being experts on both sides. There's just a dearth of experts available to the defense. And then we have the courts, who are the gatekeepers. They're supposed to, I think, fix this, though I think you can sense that there's a bit of a problem about what's brought to them from what I'm seeing. But the courts, you know, trial courts rely on expert witnesses. They rely on testimony. They have full dockets. Cases come. They may have 3 or 4 cases scheduled for trial in one day. They're not reading a lot of pleadings, and they're not reading them deeply if they're also trying to stay on top of their caseload and their other work. And so they are taking the witnesses as they come. So trial courts defer to experts. Most of the experts that testify in any of these hearings are forensic examiners. The defense rarely puts on any expert testimony. And appellate courts defer to the trial courts. The review is whether the trial court has abused their discretion. And then subsequent courts, subsequent cases, look at past cases and say, well, if they did it there, I'm safe doing it here, or what I call the problem of precedent. Right? Precedent governs the legal community. What have courts decided in the past? Science tends to work the other way. It builds on the past, but it often has sort of epiphanies or there's paradigm changes. And that is rare in the legal field, very rare. Even the Supreme Court rarely takes big steps like that. And state Supreme Courts are no more likely to take big steps like that. So that, I think, is why we saw literally nothing happen in the first 5 or 6 years of litigation. And then the PCAST report came out, the PCAST had a report come out, there was a little more, the hair analysis, the fact that there was, FBI found that there was overstatements in over 95% of the cases where testimony was provided. Things like that started to percolate in, and you saw some courts imposing some limitations on what examiners could say. But nobody, except one, I think, small trial court, that I'm aware of, has taken on the issue of what do we do if the forensic discipline has not demonstrated the validity of the claim that they can individualize to a source. What do we do? And I don't think I am only aware of one court that's really taken that issue on. So some in this room even might argue that, well, that's because the courts have been getting it right, right? The courts haven't done anything because the courts are right. The NAS was wrong. They may have been right about some of the things they said, but they were wrong about this discipline. This discipline has demonstrated its validity. This discipline has demonstrated that it can get accurate results. So to that group, I say, let's take a look at the issues on which we now all appear to agree, right? Look at the DOJ ultras, that we now all agree that we shouldn't have experts testifying that the method is infallible, that it has a 0 error rate, that there's an identification to the exclusion of all others with 100% certainty. We all now think that shouldn't happen, but it did. It did in our criminal justice system for decades. Right? For decades, those claims appeared in testimony and they appeared in pleadings. And that was not because science or scientists had yet to learn that 100% certainty was problematic or that disciplines weren't infallible. Scientists knew this, and yet the criminal justice system repeated this mantra over and over and over again. And I would suggest that that is because it was forensic scientists, lawyers, prosecutors, and defense lawyers, and judges who were in the dark ages. And so whether you agree or not with the ultimate conclusion of the National Academy of Sciences report, or the NRC report, or PCAST, or the PCAST, I think you'd have to agree that the criminal justice system got basic science wrong. And it got it wrong for a long time. So why should we trust now that they're getting it right? What's the root cause analysis been done on the courts? Have we figured out how this happened for decades? So how can we trust they're getting it right now, or that they'll get it right in the future? So I'd go back to the very first thing I said when I got here, which is thank you for bringing this group together. Because though I pointed to some other generalized weaknesses in the defense community, within the prosecution community, within the forensic science community, the overriding weakness, I would submit, with all of us, is that we don't have a background in science. Judges and lawyers rarely have backgrounds in science. Frankly, if we had, we'd have gone into medicine or engineering. We're bad at math. We were bad at science. That's why we're lawyers. And it's a rare exception, and for those of us that have struggled to try and get up to speed with it, it's been a struggle. It doesn't come naturally. And the vast majority of forensic examiners are not the people you've been meeting in this room. The vast majority of forensic examiners aren't required to have degrees in science and are very unlikely to have a background in research. So it is this kind of a group that we need if we're going to move the criminal justice system forward with respect to forensic science. I think I've met a number of people that were on the committee. I think they were hopeful that they would see change and reasonably quick change within the criminal justice system, but they were also realistic. And as a result, having seen what the criminal justice system had done to date, they reached the consensus that we needed a national independent forensic science agency. And it appears we have a model to look to in Australia to see if we can't help the criminal justice system get this right. Thank you.
Thank you, Julia. Bridget, what role do the courts have in supervising this system that at least at one point went horribly wrong?
You know, I don't think I'm going to give you a lot more to be optimistic about after Julia. I'm sorry. When the question was put to me to prepare, I thought, well, the answer is, very little has happened in the courts. And what little has happened has been random and inconsistent. And because there might be Julia Leighton in a courtroom over there, some good thing might have happened over there. And yet there's a whole big state just to the west of her where nothing has happened because there's no Julia Leighton. The problem is first of all, criminal law happens in state courts. No offense to you federal court DOJ people. It happens in state courts. 95% of criminal cases are prosecuted in state courts. And the variability of funding across all of the systems that interact in our state courts makes this incredibly complicated. Not just defenders. In my state, in Michigan, only in the last 5 years has there been an attempt to address funding statewide. And for the very first time, Detroit, Michigan, Wayne County, Michigan, is going to have a public defender office starting Thursday, this week. That's Detroit. A lot of crime is prosecuted in Detroit, and it's been funded by the lawyers who represent people accused of crimes in Detroit have been paid on an hourly system that is would shock all of you, I promise you. And you heard shocking things. I promise you it would shock you more. At the same time, the labs are funded differently across the state. The prosecutor's offices, too, have funding difficulties, many significant funding difficulties. Add to that, the judges are elected. I know, it gets worse. And there's all of those sort of systemic forces that Julia talked about, judicial review, discretion, lawyers and judges being afraid of science. It's not just that they're not good at it, they're literally afraid of it. They like to have discretion to defer to, experts to defer to, a standard of review to refer to. So it's a huge uphill climb. So I was like Julia, when the report came out, I was not on the bench. I was on the faculty at the University of Michigan Law School, and I was running an innocence clinic there. And we had a number of forensic science cases. And I used to say, oh, this report is a bombshell, it's gonna change everything. I was sure the world was gonna get fixed, and I'm here to tell you it didn't. But there have been some some pockets, like I said, and I think I have to agree with Julia that it's organizations like this or gatherings like this where I see the most hope. But I will say that I'm not sure exactly that if we do this 10 years from now, our answers are going to be a lot different. And I'd love to think about how they could be different or what we could do differently with these 10 years in hindsight. So just using, let me add one more thing about Michigan. There are only 3 states in the country that don't have mandatory judicial education. Michigan is one of them. No mandatory judicial education. So you can get elected to the bench when you're 29 and never, ever, ever have to learn anything again, and you can still be on the bench when you're 70, making decisions about science. So, welcome to our. Well, so that's the thing. So there is I always the interesting thing about. I mean, nothing percolates up to the Michigan Supreme Court. I looked at the literature. I mean, I put it in Westlaw. The National Academy of Science report has been cited in Michigan Supreme Court in things the Michigan Supreme Court has said 3 times, and it was all by me. So.
Well, we've got the right person.
So, I mean, not once in the Court of Appeals opinion, not once. Maybe in a trial court opinion here or there, but maybe because it got resolved correctly, that case never made its way to the Supreme Court. Some of obviously right after the report was issued, Melendez-Diaz cited it extensively for the proposition that forensic evidence is not uniquely immune from the risk of manipulation. That also gave me hope, right? Because that was right in 2009. I was like, oh, look, the US Supreme Court is already citing the report extensively. The world is going to change. And then kind of nothing. In my state, a couple of dissenting statements from me and one majority opinion where it was cited. Some things changed a little bit. In 2016, the Michigan Supreme Court did hold that defendants are entitled to funding for expert assistance when the prosecutor's case is centered on expert testimony. So that's something, right? That allows for maybe something to happen in the next 10 years. And perhaps the most important thing happened not in our decision-making function, but in our administrative oversight function. The thing about state Supreme Courts is often in your Constitution, the state Supreme Court has administrative oversight of the courts of the state, which means that we have a rulemaking function, and we have other functions that allow us to influence how law is practiced in the trial courts. There are 282 trial courts throughout the state. And we have this administrative oversight role. And in 2018, a rule was proposed to us, a new court rule, to change the way defendants could have motions for relief from judgment reviewed if it was their second one. The traditional rule is if you've had one motion for relief from judgment, you're out. Unless there's new evidence. And we enacted a new rule that includes in new evidence the following: new scientific evidence, and we defined it in the following ways: in a field of scientific knowledge, including shifts in scientific consensus, in a testifying expert's own scientific knowledge and opinions, or in a scientific method on which the relevant scientific evidence at trial was based. So just like that, the Michigan Supreme Court has a new rule that allows criminal defendants to come to court if they can get in through any one of those sort of new frameworks for looking at the science, if the science was important in convicting them. So just like that, an administrative rule can make a tremendous difference. And like I said at the start, state courts matter, state courts matter, state courts matter. This is my theme in every area that I'm working on, is like, but we also have this extra tool, which is administrative oversight. And frankly, you can often get stakeholders at the table with you, the defense bar, the prosecutors who want to see things done better, to help you with figuring out system solutions that I now feel are unlikely to come from litigation. Maybe they'll come in the next 10 years, but I have not seen litigation be the way to change systems. I think administrative oversight is where the hope is.
That's an important perspective. And one of the things that always is that we never really saw the flood of Dalbert motions that we saw in civil cases. The criminal cases, they just never came. In civil cases, you can actually plot the number of Dalbert cases after, and see the summary judgment was then entered. You see a spike in summary judgment, but then levels out. None of that happened. And I want to know where the Dalbert motions are.
So I've never. I know nothing about civil practice. I have never tried a civil case, but I thought about that question coming here, and I wondered, and other people can answer that: is the quality or the type or the manner of forensic evidence in civil cases oftentimes different than you might find in criminal cases? Because it strikes me that it falls under this rubric of being forensic evidence, but it can be really, really different. The stuff that's produced by crime labs, I'm not saying it's been perfect, but it is of a certain type and variety. I don't know what sort of forensic evidence is being produced into civil cases, but I suspect it could be highly different and variable. And I read about, people sort of funding their own sort of studies and research and turning that into a science that would be used to support various claims or defenses, I suppose. But I wonder if that explains some of the difference as opposed to just a more aggressive criminal practitioners.
Isn't it just money? I think it's just money. I mean, in the criminal.
Buys different types of evidence, or more litigation about it.
Yeah, real litigation about it. I mean, if the criminal defense bar had unlimited funding because there was a big verdict at the end of that was worth a lot of money, I bet we'd see a whole lot more Dalbert motions. I mean, Michigan's a Dalbert state. I have never reviewed a Dalbert claim in a criminal appeal. I've been on the bench 8 years.
I mean, I think the defense, to the extent that the defense litigated the motion, and don't get me wrong, there are a lot of very able lawyers across the country that made the most of the reports, and each report in turn as it came out, dug into them, understood them, argued them, quoted from them. But finding the expert that can defend the report, I suspect, Eric Lander's not cheap. I mean, this is really expensive to do, and not only that, you have to convince somebody that it's worth their while to come to a state court. And let me give you a quick example. We set up a hearing to challenge mitochondrial DNA evidence, and it was all about whether or not the DNA databases were adequate, given that in this case it involved an African American, and of course the African diaspora, both being enslaved and brought to the United States and then their movement through the United States was anything but random. And so we're bringing in sort of national experts and international experts to this question, 3 experts. And the government's relying on an academic expert out of Boston, but also FBI experts, so people that are in-house and available to them. The Friday before the Monday of the hearing, the Monday before the Monday hearing, the judge said, "I've changed my mind, I'm not doing an evidentiary hearing." So we pulled all the plans about bringing all these people in and started working on affidavits. The Friday before the Monday hearing, she changed her mind again. And at that point, we're trying to find, and this will date this inquiry, we're trying to find a hotel in Manaus from which an expert can testify, that has a hookup so that we can do the testimony on Monday morning. Getting an expert to sit around in an urban courtroom for 2 days who has more important things, I think, that they reasonably think to do with their lives than engage in litigation. I have, more times than not, when I've had academics testify, they say to me that was a very interesting experience and I won't do it again. It's time-consuming, and in our world, at that time, PDS was under a very different funding stream, and I had to ask these people to do it for free. To actually compensate somebody for this, I don't imagine your court's going to approve tens of thousands of dollars, which is what it costs to ask somebody to review a body of literature deeply and then fly in and spend 2 days waiting around to testify. I don't, and I, you know, some of these civil cases have unlimited resources.
There's a judge in the Western District of Michigan on the federal court who just issued a decision, an interesting decision just last week, Janet Neff, excluding star mixed DNA after a year and a half of hearings, tons of experts and briefing. In one paragraph, she says, the DNA evidence sought to be omitted in this case, in essence, that it is 49 million times more likely if Daniel Gisantiner is a contributor to the DNA on the gun than if he is not really evidence at all. It's a combination of forensic DNA techniques, mathematical theory, statistical methods, including Monte Carlo Markov chain modeling, as in the Monte Carlo gambling venue, that's actually in parentheses, decisional theory, computer algorithms, interpretation, and subjective opinions that cannot, in the circumstances of this case, be said to be a reliable sum of its parts. Our system of justice requires more. And I meant to, but ran out of time. I want to look up what defense attorney had a year and a half worth of time and money to litigate this issue. I mean, I just can't imagine it happening in state court. Maybe it will, maybe it hasn't in other states, but we just don't see it in state courts.
And I wouldn't give federal courts entirely a pass. This is also a federal court problem. The cases do come there, and they have plenty of federal cases that said the evidence was infallible and where were the FBI hair examiners testifying? These were in federal cases, and we all missed it. Nobody stopped it from happening. And so, yes, the vast majority of cases aren't there, but I mean, I'd have to pick on the federal courts and the federal court system because they can be leaders, because they do have the time. They have fewer resources. And I understand they might be considering a rule that makes them do it better.
There is discussion under the advisory committee on evidence rules about changing the evidence rule to have a more explicit requirement about reliability. And frankly, that change is directed toward forensic science. There's a lot of discussion on the committee, the advisory committee, about this rule. The Department of Justice is strongly opposed to it. And there's a real question about whether or not it's coming out of the committee to be pursued by the Judicial Conference as a proposed amendment. But that is something to watch. I think in a sense it's an expression of frustration that some have had with the slow pace that we have seen.
And one of the things I hope we hear from you all is I do think that was an amazing. How do you do those PowerPoints that have all those pictures coming in, Tony? That was quite something. I mean, there's a lot of work being done, but I hear people sort of complaining about not enough resources, not enough funding, academic interest. I gotta say, it would seem to me that if all of a sudden all the courts turned around and said you can no longer individualize, there'd be some money, there'd be some pressure. So, in some ways, I think there's all these really good efforts, but they're sort of piecemeal, and they're being, some may be being hijacked by other agendas, some may disappear with a change in administration, some may reappear with a different administration, but some unified, either that we get a national entity, or that there's some sort of moratorium that just makes all the crime labs take note. That certainly would get something done. So it's not as though the courts couldn't be an important player in this. The criminal justice system just hasn't been yet.
We're going to open this up to questions from the audience. Before we do that, or while we're doing that, let me just ask a different question about Brady disclosures. There's a constitutional obligation to present exculpatory evidence. And I've always been curious about how this gets interpreted in the context of forensic labs and the problems that may or may not arise in forensics labs and the extent to which that then becomes a constitutional obligation to disclose to the defense attorney. Mark, what happens in your venue?
Well, I don't know. Is that working?
No.
I mentioned it earlier. I did mention earlier, we obviously do have systems in place to be able to collect that information either as we observe it in court. If we understand there's a problem with an examiner and we observe that, we can kind of put it on our Brady list. We also get that information from our crime lab when they have those sorts of issues coming up through their processes. But I'm mindful too of the presentation earlier, and you know, people are going to make mistakes and people are going to have errors and things are, you know, there's a certain amount of that is not, you're on the Brady list, but we need to find those things that are sort of intentional and malfeasance of some sorts and absolutely capture that and be able to share that. So that's sort of, I think, where but I'm not sure that's a very good, that's not the place to move labs forward. And I guess my response in part is to say, again, acknowledging the limitations of what we've got here, I do think, I sense an attitude out with crime labs to say, we want to do this better, show us how to, give us the tools, give us what we need. I think they're prepared to make that jump without being told to do so by judges and prosecutors and lawyers. I think that's the greater hope.
Well, good. Somebody here should be a glass half full person. You know, the commission sort of took up something of that issue in coming up with a set of ethical rules or rules of professional conduct, and there are probably even people in the audience that, and you may better remember than I do, but one of the things that was we spent a significant amount of time discussing is to what extent labs should be responsible for reporting out and to what extent labs only had to report to prosecutors, mindful of the fact that sometimes there were examples of things that got lost between the lab, the prosecutor, and eventually getting to the defendant. And I think, you know, I think part of it is, you know, I'd propose that labs need to develop their own guidance, their own thoughts about what they're going to do about this and what the scope of that is. And I think I would suggest it should be way beyond just malfeasance or mistakes. And there are many scientists in this room that have taught me to speak very carefully, mistakes being something different than an error. An error is part of the system. There are always errors in the system. A mistake is when somebody actually doesn't follow the procedure, contaminates the evidence. But you know, when you get false results, even if they go nowhere, does that need to be reported? If the canine dog team passes all its proficiency tests, but you're aware of a bunch of false hits during training, does that need to be revealed? I think as scientists would say, you absolutely need to know that sort of stuff to begin to build the data you need to assess the method. So I think that labs will actually have to think a little differently about this than us lawyers have about what it is as a matter of science you would want to disclose to another scientist to fully understand the lab's process and method and any concerns or any issues that arise with the method.
I have a glass half full about the labs, well, at least some of them. I mean, our state police lab is fantastic, and like yours, wants to know what they can do better to be at the forefront of you know, being leaders in doing things better. But they will be the first to tell you about all the other labs in the state that are not there. And you know, I as someone charged with oversight of the system, it makes me a little bit uncomfortable that if your material goes to the state crime lab, you can have some good sense that it's being handled professionally, and yet if you're arrested in certain counties in Michigan, there's just the state crime lab will tell you totally random. So I think that's the oversight concerns me a little bit. But the Brady question is, I think the hard part is, you know, Brady is a little bit in the eye of the beholder, and again, all of the standard of review and deference built into the law makes that an unlikely way for most criminal defendants to find out about something that's gone wrong. I mean, you know, most of it's you might never know about a lot of it, and the prosecutor might never know about it. And even if the prosecutor does, the prosecutor has to determine it's something to turn over to the. Otherwise, the defendant doesn't usually find it. I find Brady to be like too little, too late. We need systems fixes at the front end, not escape hatches at the back end, I think.
And another proposal that I think's in the same commission is actually modifying Rule 16, the rules of discovery in criminal practice. And the National Commission proposed that one of the proposals was to make the criminal rules look more like the civil rules, which might be part of the reason that the civil system is more robust, is that there's a more robust discovery mechanism for expert testimony. So.
Again, when the proposals for Rule 16 have come up, it's faced strong opposition from the Department of Justice. Do we have questions from the audience?
Hi, this is not really a question, but as an erstwhile evidence teacher, I might be able to shed some additional light on the Dalbert question you posed. First of all, I mean, everything that people said about the difficulties of mounting challenges in the criminal side, et cetera, I think all that is true. There are other things that are going on. One, of course, is that the overwhelming number of criminal cases are plea bargained or they're dismissed. And if there are things going on with really faulty forensic science, that's going to affect the value of the case. I don't know of any research on this, but that is certainly a possibility. Second thing is, and one sees this not just here, but in many evidentiary case rulings, there is, not with all lower court judges by any means, but there tends to be a pervasive pro-prosecution bias in our lower level trial courts, particularly in the states, which, I mean, one of the interesting manifestations, indeed in some federal cases, when Dalbert first came down, was numbers of justices were saying, well, most of the forensic sciences were not really sciences, that there were clinical judgments, and therefore Dalbert didn't apply to them at all. I don't know if states are still taking that. But the third thing that's going on is that many of these forensic sciences are older, and they've been litigated before Dalbert, and there are state Supreme Court rulings and precedent that say evidence of this kind is admissible. And then you get lower court judges hearing these cases that say, well, you want to challenge it, we have a precedent that we can admit, say, one famous case, bite mark evidence in a case where it appeared to be almost useless. So I think those are things that complement your search for why no Dalbert issues.
I think it's very helpful. Other comments, questions?
I would add that the plea bargaining point that you make, I think, is really exacerbated if there's a system that also doesn't have open file discovery. So my office does open file discovery. We have as long as I've been there. You get everything I get. You get it virtually after arraignment, so it's not held back. That can at least facilitate some two parties saying, what are my risks, and coming to the table to negotiate. But I think that's really a bigger problem, though, if one side isn't giving up discovery.
Hi, Bethany Grounds. I was just wondering how you thought courts might affect change internationally, courts here, or if they even could. I know we've had some talk today about how this is an international problem as well, and I know of cases, even in Australia, where challenges to fingerprint evidence on the basis of the NAS report have kind of not really been accepted by the courts. So, yeah, just wondering how you think this change courts could also affect it internationally.
Well, if we can't do it here, we're certainly not going to be able to help you. I'm so sorry. I was hoping you.
We were looking
maybe,
to you to
I'll
help
tell you
us.
what. You should come here and litigate here, and I should go there and litigate there, and maybe that will make the difference. That it'll sound like an outsider, so that we won't sound like a broken record to them.
And there was it was very moving to hear your call for a global kind of consortium of looking at these issues. And I thought, like, how would that ever happen? It's like next to Santa Claus or something. But it makes so much sense. And to your point, I think you're right. We should be looking at these issues much more broadly. And part of my comments earlier were to just we move through these issues in these incredibly parochial, small, local little systems of crime labs and prosecutors' offices and public defenders' offices. And so it's very difficult for us to take our eyes up and look at the horizon. So I hope we can, and coming here helps.
Well, just one quick comment about the international judiciary. You know that the science is sort of uniform across cultures, but in each one of these countries, their judicial system is sort of firmly embedded in the culture of that country, the traditions and practices of that country. So there's a challenge in terms of educating judges about science, because you have to find a way of conveying this uniform nature of science across cultures, and yet make sure that it's put in the context of the issues that a judge will see and the issues of the procedures. The National Academy of Sciences is doing a little bit of thinking about how to prepare that kind of those educational materials and then adapt them across countries. Other questions for the panel?
We've got 5 minutes to kill. I have a couple of questions. I'm just going to ask one. It was mentioned in an earlier session about root cause analysis, trying to figure out what's at the base of all of this. And it seems to me from this panel that we don't have a justice system in this country. We have a system of trial by combat where both sides are out to win, and the system basically reinforces that. And my question is, can we solve the problem without getting at the root cause? Justice seems to disappear.
Oh, wow, that's a...
That was my easy question.
Oh, okay. All right, to be clear, I've done my fair share of bashing my own system here. I must say that as imperfect as it is, I struggle for a less imperfect system to find examples of that. And that's why I think I really am not suggesting that there's some radical way you could change the criminal justice system, but that we need support from the scientific community, that we need an entity that is a far more sophisticated gatekeeper than an individual judge can be in an individual case in a courtroom. And the adversarial system, you know, it has its strengths. It has some weaknesses, but it has its strengths. The problem is that it's very hard to do in one case the big picture stuff. You know, I'll give you another example. We get all dressed up and ready to litigate. We have the experts. We've paid the money. We've had the research done. We walk in, and the government turns around and makes an exceptional plea offer. You know, for that defender office, that was essentially money down the tube, because that was a plea offer. The client, in the interests of the client, it was so little prison time that that person should take that offer. So it's you know, we had another example where we did a big days long admissibility hearing. Great record, I thought. And then the trial lawyer won the case. So there's no appeal. It's not, but those things aren't something that's wrong with the system. It's just why the system can't answer some of these big questions very well. I don't know if that's helpful to you.
Yeah, I think we do need to have a big, you know, root cause error analysis of the whole system. But I think the biggest problem is the guilty pleas. I left that out of. You're absolutely right, Rick. I mean, you know, most cases plead. We do not have open file discovery, and the system depends on 95% of people pleading guilty, and we have traded what the founders thought was important in the jury trial right for efficiency. And so I think it's not just trial by combat, it's something big. This analysis we're about to do is going to be, it's bigger than just what's wrong with the trial process, because it's mostly not a trial process.
Let me just conclude by mentioning something that Judge Harry Edwards said in the context of the National Academy of Sciences study. He basically acknowledged that the court system
has certain limitations in terms of the extent to which it can really affect change in these cases. And from the outset, those of us on that panel knew that the progress was going to take place when the forensic science community itself started taking steps in this direction. And I think it's a wonderful thing to see this kind of conviction emerge. And I believe this trend is going to continue in the future. And I think that is one reason for hope. Are we at time here? Okay, thank you. Would you please join me in thanking our panel?